Hi everyone, welcome back to Andy on Crime. Today we're going to look at the case of CHED Evans, the professional footballer. In this video we're going to look at the circumstances surrounding his appeal and subsequent acquittal after he was originally convicted of rape and sentenced to 5 years in prison. I hope you enjoy. So starting off with some facts about this case, CHED Evans was a footballer for Sheffield United when, in April 2012, he and another footballer, Clayton MacDonald, were accused and stood trial for the alleged rape of a young woman. Clayton MacDonald was ultimately acquitted, but CHED Evans was found guilty and sentenced to 5 years imprisonment. He served half of his sentence, so was released after serving 2.5 years in prison, with the rest of the sentence to have been spent on licence. CHED Evans first attempted to appeal his conviction in August 2012, which was rejected, and then he subsequently appealed again, which again was rejected in November of 2012. He then approached the Criminal Cases Review Commission, which looks at potential miscarriages of justice, and his case was taken on, and an appeal was made by the Criminal Case Review Commission to the Court of Appeal on the basis of new evidence. That appeal was heard in front of the Court of Appeal, who quashed Evans's conviction and ordered a retrial to take place. At the subsequent retrial, CHED Evans was acquitted of the offence and is no longer subject to any criminal investigation. So in this video I'm going to look at what happened in relation to that appeal and why he was subsequently granted a retrial. So the first thing to understand in all cases involving sexual offending is that Section 41 of the Youth Justice and Criminal Evidence Act of 1999 prohibits the defendant or their defence counsel from asking questions of the complainant in relation to their previous sexual history. The only circumstances that they can do so is with permission of the court and subject to 4 exceptions, which I will briefly cover now. Now I will cover them just briefly, so anyone with any legal background will know there's a bit more detail, but to understand this case I need to briefly outline what those exceptions are and which one applies to this case. The first exception is that the questions about the complainant's previous sexual history do not relate to the issue of consent in the present case, i.e. the defendant's defence is not that the complainant was consenting, and the questions relate to another issue in the case, such as whether the act happened, as an example. The second exception is consent and contemporaneity. That is where the issue relates to consent, and the questions the defendant wants to ask are about matters that are alleged to have taken place at or about the same time as the offence being tried. An example of this would be where an allegation of rape is made and the defendant wants to adduce evidence that only an hour before the defendant and the complainant had consensual sex as a way of demonstrating a reasonable belief in consent with the offence charged. The third exception is known as consent and similarity. This is where the issue in the case is consent, and the sexual behaviour that the defendant wants to ask the complainant about is so similar to either the behaviour of the complainant at the time of the present case, or any other sexual behaviour of the complainant which took place at or about the same time as that event, and that these similarities cannot be reasonably explained as a coincidence. Simply put, the questions the defendant wants to ask relate to an encounter where the complainant has engaged in sexual behaviour so similar to the case being tried, or other sexual behaviour not subject to the case but that took place at or about the same time as the offence in question. The fourth and final exception is known as rebuttal evidence. This is where the prosecution has adduced evidence about the sexual behaviour of the complainant, and the defendant wishes to adduce evidence to rebut or provide an explanation on behalf of the accused. It is for the defence to make an application to the court to adduce evidence of the complainant's previous sexual history. If the judge fails to be convinced that it meets one of the 4 exceptions, then no questions may be asked. And even where a judge does grant permission for the defendant to ask questions of the complainant's previous sexual history, there may be limitations placed on it to ensure it does not go beyond that which is necessary in the case. So what happened in CHED Evans' original trial? Well, in his original trial, no application was made to adduce evidence of the complainant's previous sexual history. In that case, CHED Evans ran a defence of consent, i.e. that he had consensual sexual intercourse with the complainant and that he had a reasonable belief in consent. Now, during his evidence, he also highlighted particular sexual activity and particular words that were used by the complainant during that alleged sexual activity. Now, this defence was disbelieved by the jury and he was convicted of rape and sentenced accordingly. As I mentioned at the start of this video, he appealed his conviction twice, but on both occasions was refused, with the court stating, "We can see no possible basis which would justify us from interfering with the verdict of the jury, which heard all the evidence and reflected on it after careful summing up by the trial judge." So what changed after those two appeals were refused by the Court of Appeal? What changed was that in July 2014, Evans appealed via the Criminal Cases Review Commission, who took on his case, and based on new material, which was not considered at the original trial, they referred the case to the Court of Appeal in October 2015. In April 2016, the Court of Appeal announced that the appeal was successful and that CHED Evans' conviction had been quashed, with the court ordering a retrial. The evidence that proved to be the key factor in the successful appeal was that two other men had subsequently come forward and described specific instances of the complainant behaving in a very similar fashion with them in the days before and after the alleged rape was said to have happened. On each occasion, the complainant had been drinking and during sexual activity with the men on separate occasions had directed them into certain positions and used specific words of encouragement. The questioning of the complainant in this manner would, by default, have not been allowed, subject to those exceptions I highlighted earlier. On that basis, the conviction was deemed unsafe and a retrial should be held for the trial judge to consider whether to allow the defendant to adduce this evidence at trial. During the retrial in October 2016, this evidence was permitted under the exception of consent and similarity, and the jury heard evidence of the complainant's behaviour with two other men in the days before and after the alleged rape. The prosecution alleged that the new witnesses were being fed information by Evans' defence team and were motivated by a £50,000 reward, but this allegation was rejected by the jury. On the 14th of October 2016, Evans was found not guilty of the rape and acquitted. So to summarise, at his original trial, Evans' defence of consent was rejected by the jury and he was convicted of rape. After his release on licence, his case was taken up by the Criminal Case Review Commission when new evidence was discovered which convinced the Court of Appeal to quash his sentence and order a retrial. At his subsequent trial, he was then allowed to adduce evidence of the complainant's previous sexual history on the basis of consent and similarity, and after that retrial he was found not guilty. Thanks for watching. I hope you found this video informative. If you do have any comments, please post them down below. Please do bear in mind that it is a criminal offence to identify the complainant in this or any other sexual offences cases. I will have to remove any comments that could identify the complainant. If you did enjoy this video, please consider giving it a like, and if you want to see more content, please subscribe to my channel. Thanks for watching. Take care.